Muy buenos días, estamos con el doctor Matthias Klatt, que acaba de terminar una muy interesante conferencia en nuestra facultad sobre el uso de precedentes extranjeros. Welcome, Dr. Klatt, to our Faculty of Law. We're very glad to have you here. And thank you very much for this very interesting and so important lecture on the use of foreign precedents. I would like to continue this dialogue that we have started in your lecture, asking you about what is the German or the Austrian perspective of the use of foreign precedents in constitutional adjudication.
So, if we look from a comparative perspective across the various courts in the world, we can see that some courts are using foreign precedents very often, some nearly don't use them at all, and then we have a middle-ranged court, let's say, they use it sometimes, but not always, and maybe not in a very systematic way. So I would place, from my experience, the German Federal Constitutional Court in this middle slot, let's say. Okay. They cite foreign precedents, yes, and over the last years they may even be doing it increasingly so, but they are not yet at a level where they systematically research and evaluate foreign precedents across a broad range of legal systems, as, for example, the Strasbourg court is doing.
Okay. It is surprising to me to hear that the German Constitutional Court uses foreign precedents. I think that the German court is one of the leaders in the world when it comes to fundamental rights adjudication or to constitutional adjudication because of the federal German system and other German features. I wonder which foreign precedents or which foreign countries does the German Constitutional Court would follow?
Yeah, so as I said, it's mostly not a systematic research being done, but rather a bit like this cherry-picking problem we have in the scholarly literature. For example, I know of foreign citations in freedom of speech cases a lot. I know of foreign citations in cases which concern the use of the public space. But clearly, the extent to which foreign precedents are being cited will, among other things, depend on the judge rapporteur. So the judge actually preparing the decision for the Senate, if that is a judge who likes reading foreign precedent, if that's a judge who is familiar with foreign legal systems, he or she will bring those foreign wisdom more into the legal judgment than different judges.
Okay. Yes, of course, there can be an express influence on our own judicial decisions from foreign precedents, but it could also be exerted and a silent influence in these decisions. For example, when a court doesn't cite and doesn't refer expressly to another precedent, let's say New York Times versus Sullivan in the American system, but I apply the actual malice standard for freedom of expression for freedom of expression case. Is there in Germany or Austria a case like this in which their respective courts have employed but silently a foreign standard?
So yeah, it's a good question, and it concerns the question of transparency, right? So does a court lay open all arguments that have influenced their decision? And here the answer, I think, for all courts in the world is no. No court in the world will lay open all arguments they have been considering in the process of finding the decision. We must distinguish here between the context of discovery and the context of justification. That is very important.
Yes, this difference is very important for every issue of legal argumentation. Indeed, when a court is preparing its decision, it could consider a lot of topics, a lot of reasons, a lot of elements of reasoning, foreign precedent, policy considerations, and so on. But this, the decision would be formalized in a text, in a specific wording with some specific content, and then that will be the will of the court. Am I right?
Yes, exactly.
Yeah? Yes.
You're absolutely right. There is no obligation whatsoever for a judge to lay open all the arguments from her context of discovery. And there is no obligation because it's also even impossible for anyone. Mm-hmm. What matters from the legal normative perspective is that those arguments that are listed in the statement of reasons for the judgment in the written decision, that those reasons actually justify the decision, and they form together a coherent and logical deductive legal argument for the decision. That is important.
This could be applied, and I will to look to another matter, but very related to this one. This could be applied for the proportionality reasoning in a judicial decision. In order to justify a certain balancing or certain decision based on a proportionality sub-principle, let's say the suitability or the necessity sub-principle, we can skip some arguments, or we can jump from the definition of the problem to the balancing directly without going through to explain the suitability or the necessity of a measure that restricts fundamental rights, for example, and we just simply jump to the last phase of this test, of this proportionality test. Can we say something similar regarding these situations? Mm-hmm.
Yeah. So in particular, when the proportionality test's result is negative, yeah, if we say something is disproportionate, and for example, some state measure was disproportionate because it was not well balanced in the sense of the proportionality in the narrow sense, then already this argument will justify the final judgment. For example, the declaring of a statute being void for disproportionality. Only if the statute is being upheld by the courts, by a constitutional court, so if the statute is not being declared void, then all subtests of the proportionality test must be fulfilled cumulatively, yeah? And in that scenario, it's not possible to skip one of the subtests. You must test all subtests in that scenario.
Yes, thank you. Getting back to your lecture, you have mentioned this idea argued by Jeremy Waldron, the jus gentium, who is talking about a a broad world consensus on a legal matter that would be binding to a national court. How can we determine when this consensus has been reached, or it is impossible to say? So we can assess when this consensus, in the sense that Jeremy Waldron talks about, has been reached. Is it impossible, or could it be a situation in which we could say there is a jus gentium, a world legal consensus over this principle or this matter?
Yeah, it sounds so clear, this argument, right? But drawing to a consensus and to a jus gentium. But as a matter of fact, for example, it doesn't help us in many, many cases, because the hotly disputed cases, we just don't find any consensus. And the problem, though, goes deeper than that. It is from the very start unclear to what extent a consensus can be a normative justification for any reason, because that many countries agree or disagree on something is a pure empirical fact. And from empirical facts, as we know, it is impossible to draw any normative conclusions. So in that sense, we must realize that the consensus argument is not a very strong argument at all. It can be some indicator of us looking into deeper justificatory substantive arguments, yes. That a consensus argument can achieve, but again, the mere fact that some countries disagree on some legal solution is not a normative argument at all, because all those countries can indeed be wrong. Think of countries like dictatorship countries. Yes. So you have like 8 dictatorship countries, all have consensus that torture is a great thing against your enemies. Excuse me, that is utterly morally wrong. So this is why consensus is a bit tricky.
Yes, it is hard to say there is an authority that can count the votes in the international community, or in order to have this consensus assessed. Finally, you have been in Mexico for a couple of times. You have talked with Mexican lawyers, and maybe you have shared, you have had conversations about legal issues in Mexico, international law, and other things. How do you see the Mexican legal community's openness to foreign precedents or to international law? How do you see the Mexican legal community in front or regarding this international dialogue that we're having in legal affairs?
So I do realize I may have a very limited perspective to answer this question, in the sense that as an international traveling law professor, I live in a certain bubble, of course, and I have only limited insights into the Mexican legal system. I meet certain people in Mexico, yes, you are absolutely right, but they may also live in this bubble, the bubble that is being informed by international scholars. Having said that, however, I can share with you the following impression I have. It's a purely personal impression, I grant that. And the impression I have from my travels to Mexico is this: that I have encountered a great many number of scholars, of lawyers, of academics, of judges, who are indeed very, very open, very, very interested in learning from foreign law professors. I find it amazing and stunning how rich the openness is, how rich the impact is, the knowledge you buy in from foreign law professors during these grand conferences and so on, last week, next week at the Quarter. So in that respect, I can say that I am deeply impressed by the openness to receive foreign wisdom in the legal discipline. And I underline this so because I, of course, contrast it with the narrow-mindedness, if I may say so, in my home countries in Europe.
Thank you very much, Professor. We really appreciate your time, your effort to be here with us. We are very grateful to you for this magnificent lecture you have delivered a few minutes ago. Thank you very much for this dialogue, for this little conversation with you. We are very grateful, and I am sure that the students of the Faculty of Law of the Autonomous University of Yucatan are very grateful too for your consideration, for your help, and for your wisdom. Thank you very much. Y muchas gracias a todos y todas que nos han acompañado en este esfuerzo más por consolidar la internacionalización de nuestra Facultad de Derecho. Muchas gracias. Okay.